Graham, are you okay to put up my slide? Thank you. So the topic I've been asked to speak on today is a decade of development in Scots law. Now, obviously, I'm going to tailor this to the area of law that I practice in, and which is most relevant to anyone who has suffered a brain injury. Of course, there will have been other developments in Scots law that don't impact upon the work that we do, maybe in the commercial sphere, for example. So we'll not touch on those today. Could you move on, Graham, please, to my next slide? So I managed to find the programme for the first ever Head Injury Information Day. It's probably quite small on your screen. But as I mentioned in my opening remarks, the idea behind launching the Head Injury Information Days in 2011 was and very much remains a desire to promote services and opportunities for those with a brain injury. And as Chris was reminding us there, a very important service that sometimes exists for people is when they have a claim. And so part of that, in addition to promoting the services, is also to promote the legal and welfare advice that is available out there. And I said, the eagle-eyed among you will see that Simon Glenn's name features on that, and Simon's going to be speaking to us later on today. If we could move on to my next slide. I thought I would try and jog your memory with some of the things that happened in 2011. So this picture is taken from Sky News, a review of 2011. But just to give it some context, and I'm sure everyone who's been doing Zoom quizzes over the last few months during lockdown is completely up to date with what happened in what particular year. But these are some of the things that happened in 2011. You'll note one of the things there is Novak Djokovic winning his first Wimbledon. Obviously, he's been in the headlines for other reasons this year. Other notable things which aren't on that slide are from the media. Charlie Sheen was fired from 2.5 Men. Game of Thrones premiered in 2011 for the first time. Steve Jobs resigned as head of Apple because he was unwell. And Craig Levine was the Scotland manager. So that's just a little bit of context about what was happening in 2011. Could you move on to the next slide, please, Graham? But the legal world has not stood still in those 10 years, and we have, in the area of law that I practice, seen two quite significant changes. The first has come in relation to the courts, and in the form of the Court Reform Scotland Act 2014. And the second has come in relation to civil litigation procedure and expenses in the form of the Civil Litigation Expenses and Group Proceedings Scotland Act 2018. Thanks, Graham. If I could have my next slide, please. So the genesis for these two acts were two major reviews which took place. The first, which took place in 2009 by the gentleman on our left, Lord Gill. And Lord Gill carried out what was described, or what was meant to be, a root and branch review of the civil court system in Scotland. And his aims were to improve access to justice in the civil courts, and to provide a more efficient and a more affordable court system. So Lord Gill reported, and then I'll come on to talk about some of the changes that were implemented in a second. That was very much the first review. And then in March 2011, the gentleman on our right-hand side, that is Sheriff Principal Taylor, he was commissioned to undertake a review of costs and funding of litigation in Scotland. And he issued his report in 2013, and his report set out 85 recommendations. He undertook a similar exercise to that which had been undertaken in England by Lord Justice Jackson. And his review really looked at shaping out how people could fund litigation in Scotland. If we could have my next slide, please, Graham. So before dealing with Lord Gill's review and the subsequent legislation, I thought it'd be useful to give a quick overview of how the civil courts work in Scotland. It's not particularly complicated. So you'll see at the top of the screen the little bubble civil court, and if you go down to the bottom of that, the lowest civil court in Scotland is the Sheriff Court, and then above that sits a higher court, which is the Court of Session, and then above that is the Supreme Court of the United Kingdom, which sits in London. Both the Sheriff Court and the Court of Session in Scotland are both courts of first instance. That's where you bring your action in the first place, and they also have appellant functions or appellant bodies within them. So if you don't like the decision or you're unhappy with the decision, and in certain circumstances you would have the right to appeal either to in the Sheriff Court, the Sheriff Principal, or possibly to the Court of Session. So those courts exist. In the Sheriff Court, a solicitor can appear or counsel can appear, and in the Sheriff Court, in the Court of Session, only advocates, only counsel can appear, although they have to be instructed by a solicitor. So as a general rule of thumb, it is much more expensive to litigate in the Court of Session because, generally speaking, you need to employ the services of an advocate and very often a QC. If we have our next slide, please, Graham. And then the courts, I'll not bore you with too much technical detail here, but the courts, particularly Sheriff Court, are separated into different areas, and there's different rules that govern the different areas. So some people have heard of the Small Claims Court, that sits under the Sheriff Court, and also there's a cause called summary cause, or a set of rules, which is a specific type of hearing. And then what most cases tend to go through is what's called the ordinary procedure. And then in the Court of Session, above that, you have the Outer House, which is the Court of First Instance, and the Inner House, which hears appeals in Scotland. So that's just a quick run through of how the court's structure works in Scotland. So if we could have my next slide, please. So what changes did Lord Gill recommend, and what was actually put into the legislation? Well, his first change was that the Court of Session had a threshold of £100,000. That means only cases with a value of £100,000 or more are to be litigated in the Court of Session. Anything below that must be raised in one of the Sheriff Courts. And that was an important distinction to try and limit the forum where actions were raised in an attempt to control costs. And then for the first time, Lord Gill suggested that there should be a specialist court for personal injury. Now, we had seen specialist tribunals like an employment tribunal in Scotland, and we have seen there's a land court, but this was the first time a specialist personal injury court was ever to take place. It was meant to sit in Edinburgh, and it was meant to cover all of Scotland. So sheriff courts in Scotland are generally divided into areas, and you have to raise a action in your local sheriff court. There are certain rules that govern that, but as a rule of thumb, you tend to raise it in the court that's closest to you. The All Scotland Personal Injury Court was to be a sheriff court that covered the whole of Scotland, and it opened for business on the 22nd of September 2015, and it had jurisdiction over all personal injury actions for damages, which were greater than £5,000 if it was a road traffic case, or over £1,000 if it was an industrial accident. And the All Scotland Personal Injury Court, or ASPIC as we call it, has power to move proceedings up to the Court of Session if it thinks that that is appropriate. So for the first time in the sheriff courts, really claimants had a choice of forum as to where they were to raise proceedings. The idea behind Lord Gill's thinking was that it would keep costs low if solicitors and if advocates were needed didn't have to travel all over the country. It would also allow for a consistent approach and allow for best practice to develop in the All Scotland Personal Injury Courts. Lord Gill was also a fan in what's called a case management, and that's where the courts get more involved in the running of a case. I'm going to talk about that slightly later, but that was one of the big things that he was pushing in this All Scotland Personal Injury Court, that there would be greater intervention from the bench. And finally, for the first time in Scotland, a civil jury trial could take place in a sheriff court. Now, that was restricted to the All Scotland Personal Injury Court. Prior to that, all civil jury trials took place in the Court of Session. But the rules which were put in place very much mirrored those which were in place in the Court of Session for jury trials. So there were the big changes, the big ticket items which we've seen in court reform in personal injury in the last 10 years. If we could turn then, Graham, to my next slide. So Sheriff Principal Taylor's 85 recommendations, some of them turned into the Civil Litigation Expenses and Group Proceedings Scotland Act 2018. And the first, one of the biggest areas that he targeted from our point of view, was litigation funding. So for the first time, solicitors in Scotland were authorised to enter into what's called a DBA, a damages-based agreement. And that's probably where you've heard of no win, no fee. What we've had to do up to now is we've had to have a separate company that deals with our funding and our expenses side. But for the first time, solicitors could enter into it directly. But the fees that solicitors could charge as a result of this new piece of legislation were then capped by statute. And that meant that a solicitor couldn't charge just whatever he or she chose, but their fees were to be limited by regulation. And those regulations came into force on the 27th of April 2020. Another one of his major recommendations was for a thing called a qualified one-way cost shifting, or QOCS. And that essentially was designed to give pursuers a degree of protection. Up to now, still, the position in Scotland is that if you lose a case, the loser pays. So if you raise a court action and you're unsuccessful, then you become responsible for your opponent's costs. That's why we have damages-based agreements, to put in place policies that protect you in those situations. But what Sheriff Principal Taylor recommended was that those costs would just be borne by each party. So if you were unsuccessful in your claim, the defender couldn't come to you and ask for the money back. But that was limited in certain circumstances, and Section 8 of the Civil Litigation Expenses and Group Proceedings Act sets out a number of situations where that might not apply. One would be if someone has made a fraudulent representation or otherwise acted fraudulently in connection with the claim or the proceedings. So it's to stamp out any fraudulent or unwelcome or unwarranted representations during a case. It's also likely to have an impact if anyone, either the solicitor or the claimant, has behaved in a manner that is manifestly unreasonable in connection with the claim or proceedings, or otherwise conducted the proceedings in a manner that the court considers amounts to an abusive process. So in those situations, once a one-way qualified cost shifting comes in, if any of those behaviours are evident throughout the case, then that could result in finding of expenses against the pursuer or the defender at the end of a case if their conduct is deemed to have breached that. And then Section 20 dealt with what's called group proceedings. And again, this has not yet come into force. But for the first time, this allows a group litigation in Scotland. Now, at the moment, as I said, there's no sign of the rules, although I understand that a working group has now been set up to look at this, and that informal consultation process has actually begun. But when this comes in, for the first time, a group of people will be able to raise an action in a court in Scotland, and all of the parties in that will be bound by the outcome. So that's the sort of a second big change which we have seen, and I said some of that still has to come into force. I think, unfortunately, the current global pandemic has slowed up the introduction of QOCs and of group proceedings. Okay, if I could have my next slide, please. And then the other big change in personal injury law certainly has affected the type of work that we do in the department that I work in, is a thing called the discount rate. Now, just to explain a little bit about this, so damages in Scotland are based on what's called the principle of restitution. That is, they are designed to put the injured party in the position that they would have been in had the accident not happened, insofar as money can do that. And the idea is that you receive the precise amount that your losses will be, not a penny more and not a penny less, to quote Lady Hale in the English case of Simon in 2012. But the problem with a lump sum award, which is what courts are restricted to awarding at the moment, is that a lump sum award will be impacted adversely by inflation. So what £100 is worth today, it will not be worth in 20 years' time. But the flip side to that is that the person receiving the lump sum has the opportunity to invest it, and therefore receive a return on that investment. And really the discount rate is to try and sort out that tension between the impact of inflation and the ability of your damages to be invested and make a return. Now, for a long time, the discount rate was a positive at 2.5%. So that meant that you were making a good enough return on your investments, which were to be invested in government stock, that the yield that you got from that meant that your damages were to be discounted by 2.5%. That's it in very sort of bald terms. But what happened was the government stock that you were meant to be investing in stopped producing a yield, and therefore for a long time people were losing out because it wasn't making the 2.5% that they needed. And so this was reviewed, and the discount rate dropped to a negative figure. Now that might sound like not a good thing, but it actually meant that the value of your claim then went up quite substantially for some of your future losses, the way the calculation was put together. So that, in many respects, for most heads of claim, was a positive thing, particularly when we were looking at care and other future costs or other future heads of claim that would be part of your case. The downside, of course, was that it had an impact on accommodation claims. So when someone has a serious accident, one of the things which we may have to look at, not in every case, is accommodation. Is there accommodation suitable? And if not, then one of the things which we can do is include a claim for loss of accommodation. And the courts, in an English case called Robertson against Johnson, set out a calculation for how you value accommodation claims. And the idea was that you would multiply the sort of capital cost of the property by the prevailing discount rate, and then you would apply the appropriate lifetime multiplier to come up with the figure that should be awarded for an accommodation claim. The logic behind that was that it was to stop the claimant's estate from having a potential windfall, assuming that the accommodation appreciated in value over the claimant's lifetime. It wasn't a perfect system, but it was a system that the courts had in place and a system that we all had to work with. But a negative discount rate meant that accommodation claims then effectively came out at nil, which caused a headache for everyone who was running litigation in Scotland and in England, because accommodation claims then just became, the way they were calculated just became a nonsense. So on the 23rd of June, the Court of Appeal in England heard a case called Swift against Carpenter, and it is now considering what approach should be applied to accommodation claims so that people who need accommodation are not adversely impacted by a negative discount rate. Unfortunately, the opinion in that case isn't out yet, and we're waiting that coming from the Court of Appeal in England. Whether or not it is in appeal to the Supreme Court, we'll just have to wait and see. Do you have my next slide diagram? One of the other big changes which we've seen as well is the intervention of or the introduction of judicial case management, and this is where a court becomes more involved in the sort of day-to-day management of the claim. Ordinarily in Scotland with a personal injury claim, what happens is when an action is raised and defences are received, a court fixes a final hearing and a timetable is issued, and really the court doesn't get involved until the final hearing. But throughout that timetable, there are certain dates that are in place for parties to try and settle the case, to get together and talk, to put in valuations, and the whole procedure is really designed for parties to try and sort the case out amongst themselves, and very little judicial input is required. And by and large, it works well. Very few cases actually ever need a judge to hear anything in the case. It just ticks along and parties can sort it out between themselves. However, more complex cases like a business case or a serious injury case involving someone with a traumatic brain injury, it's sometimes possibly more appropriate for the courts to get involved. And so a special set of rules have been put in place that allows the courts to get more and more involved in the procedure. And what it allows the courts to do is to fix case management hearings, where parties have to come before the court and update them on where they are. But it also requires parties to provide certain information by certain dates. So it may well be that a court will ask for all the parties to have exchange of the reports before a case management hearing, or even to exchange a draft list of witnesses, or to have a draft statement of proposals and counter proposals, or to agree a joint bundle of documents. And the court, again, is trying to funnel with its involvement parties towards either focusing their minds on the issues and disputes should the case go to court, or on settlement. And again, we've seen quite a lot of success through that, where cases have been managed to be resolved without the need to ever go to a final hearing. So that's a brief run through a decade in personal injury law, and how the courts and how the funding system and the procedures have changed over the past 10 years. I appreciate it's maybe a little bit technical, but if anyone does have any questions, I'm more than happy to answer them.
Hi, Chris. Thank you so much for that. That was very interesting, and apologies, we have run out of time.
That's okay.
I have to move on swiftly now to introduce my next speaker. So thank you for your time today, Chris.